Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 86. First things first, apologies for the quality of my voice in this episode. I'm suffering the after effects of the cold that's doing the round, which has left me sounding on occasions as if I'm a combination of a 20-a-day man and sounding a bit like Bob Dylan on a bad day. So we'll see if we get through this uninterrupted, but if there are any unexplained silences, it's because I've gone off to cough. Secondly, today is my 52nd birthday, so happy birthday to me and all that. There are two views on my 52nd birthday in my house. There's my view, which is a handsome man in the full vitality of his life. And then there's the view held by my teenage children, which differs somewhat. Mind you, since my younger son turned 18 about 10 days ago, he's not getting any younger either, as I pointed out to him. Anyway, to business. We've got three cases. The first, a European Court of Human Rights decision looking at an employer's right to monitor and access an employee's communications without their knowledge, and looking at the sort of circumstances which might justify intervention by employers. Secondly, we've got an EAT case which considers the necessary elements of a direct age discrimination claim, and in particular the EAT looks at the question of comparators and what tests should be applied to determine whether the employee has suffered less favourable treatment than the comparator. And lastly, we take a look at an unreported Court of Appeal case, and it considers whether an employer's policy of requiring all employees and applicants, job applicants that is, to demonstrate their ability to work in the UK could be considered discriminatory on the grounds of nationality. So first up, Barbulescu and Romania. This is a decision that's come down from the European Court of Human Rights and looks at an employer's right to access, monitor, read an employee's private email messages sent and received from the employer's equipment during working hours. It has had a lot of misleading publicity, this case, and in particular the outcome, although possibly my favourite comment that I saw was that it's the first time that the Daily Mail seems to have been upset that the European Court of Human Rights has failed to uphold someone's human rights. Anyway, to give you a brief overview, Mr. Barbulescu was employed in Romania as an engineer, and he was asked by his employer to set up a Yahoo Messenger account for work purposes in order to email clients during the working day. His employer believed, however, that Mr. Barbulescu was using the account for personal use in contravention of the employer's internal policy. Consequently, the employer decided to monitor the use of the Yahoo Messenger account and subsequently discovered, guess what? That his use of the account had indeed been for personal emails and therefore contrary to company policy. When asked about his use of the account for personal messaging, Mr. Barbulescu denied using the account in this way. However, he was subsequently presented with evidence of the personal messages he'd sent from the work account, following which he was dismissed for contravening the company's internal rules. And those rules expressly stated that it is strictly forbidden to use computers, photocopiers, telephones, telex, and fax machines for personal purposes. Well, he brought a claim in the Romanian courts stating that his employer had violated his right to private life and to protection of correspondence in accordance with the Romanian constitution. However, the Romanian courts dismissed his claim on the basis he'd been aware of the employer's policy on usage of the account and work computer equipment. He unsuccessfully appealed the court's decision, after which he went to the European Court of Human Rights. Well, at the ECHR, he claimed that his emails were protected under Article 8 of the European Convention on Human Rights. He had a right to respect for his private life and correspondence. The ECHR's judgment was limited to a consideration of whether the employer had the right to monitor and read the private email messages, and whether the Romanian court had struck a fair balance between the employer's interests and Mr. Barbulescu's rights in coming to its decision to dismiss his claims. Interestingly, the ECHR felt that although Article 8 had been engaged in this case, it had not been breached. Instead, it held that a balance had been struck between employer interests and employee rights in the Romanian court's decision. In accessing and reading Mr. Barbulescu's emails, the employer had been acting within the rules set out by its internal policy. It was not unreasonable for an employer to take steps to ascertain whether employees are completing their professional tasks during working hours where their policy permits them to do so. The employer had conducted a formal disciplinary procedure, and the initial access of the Yahoo Messenger account was made in the reasonable belief that it contained personal messages. Additionally, the transcript of the personal messages had only been used to show that Mr. Barbulescu had been sending personal messages from that account on work computers during working hours. No further information was revealed about the content of the personal messages by the employer. They were simply evidence of his improper use of the account. Equally, the Romanian judgment didn't reveal the precise details of those messages or attach any weight to the content of the messages, just the fact that messages of a personal nature had been sent in contravention of the employer's policy. So the European Court, therefore agreed with the earlier findings of the Romanian courts, concluding the employer had acted within its disciplinary powers in dismissing Mr. Barbulescu, and that a fair balance had been struck by the courts when they came to that decision. Well, the ECHR decision does help to provide a degree of clarity around the personal use of computers and the internet whilst at work, where such personal use is clearly in contravention of the employer's policies. You can imagine what would have happened if the case had gone the other way. And the case acts as a reminder to employers to ensure that if they intend to prohibit personal usage during the working day, or on work equipment and so on, that they should have a very clear policy setting out the rules. This should expressly provide for usage on internet and equipment at work to be monitored and also deal with possible scenarios that could constitute breach and the consequences and sanctions that can arise from any such breach. A well-drafted policy is key, and the decision in this case may well have been different had the employer not had stringent policies in place, and had the employee not been warned that this account and internet usage was for work purposes only. However, I think it would be concerning and distinctly unwise if UK employers saw this case in the way it had been reported in some of the press, i.e. as a carte blanche to monitor private communications of an employee in the workplace. Instead, this case should act as a reminder that monitoring computer usage needs to be undertaken in a reasonable and proportionate manner and within the context of the issues involved. If employers intend to monitor their employees' communications whilst at work, we'd recommend this is done in a proportionate manner, not necessarily without notifying employees in some way, whether maybe you notify them verbally or contractually or via staff policies, some sort of advance notification. Here, the employer clearly acted within its disciplinary powers, and its written policies and procedures expressly gave them these powers, and it didn't go beyond these powers in any way. Under English law, of course, there's a regulatory framework which employers must comply with, both under the Data Protection Act 1998 and the Regulation of Investigatory Powers Act 2000. Employers cannot and really should not see this case as a reason for failing to comply with those UK statutory obligations. That being said, I don't think anything in the English legislation would have produced a different result on the facts of this particular case. It was just you need to be clear what the limitations are for the case. Having said that, for those of you who are minded to do so, there's a really interesting dissenting judgment in the case from a Judge Albuquerque, which takes considerable issue with the outcome, which makes for very interesting reading, even though it is only a lone dissenting judgment. So, that's the Barbulescu case. Next up, the Donkor, D-O-N-K-O-R, and Royal Bank of Scotland. Well, this is an EAT case which looks at the issue of comparators in a direct age discrimination claim and considers the relevant test that needs to be satisfied for a direct discrimination case to be made out. And this is obviously at the very heart of discrimination law. What's the true comparator? Because that's the yardstick by which you use to measure whether discrimination has occurred, whether the employer has been called to account for anything. And it may help in this case to take things in a slightly unusual order, explain why I think it's significant, before going on to deal with the decision itself. So, roll with me here. We've been involved in a number of cases and had discussions with a number of employers on top of that about the challenges being presented by having an ageing workforce, often with lucrative pension benefits attached to the employment of the older employees. In many cases, of course, we've seen final salary schemes closed or closed to new entrants, which means there's an imbalance in the pension benefits being made available. Older employees, often have enhanced pension rights, which may be pretty generous in comparison with the pension rights made available to younger employees. Older employees who are made redundant may often have rights to enhanced pensions as part of their contractual terms if they are made redundant. We've certainly seen a number of instances where employers have been very concerned about the costs of a redundancy exercise becoming uneconomic if employers are forced to be blind to the enhanced pension cost that they would incur by making, say, a 55-year-old redundant as compared to a 45-year-old redundant who might be on a significantly different pension package. So we've seen employers in my terms, contort redundancy exercises, both compulsory and voluntary, to avoid landing on the wrong square, if I can put it this way, and ensuring that they keep the right, i.e. the older and more expensive employees on, and make redundant the younger and cheaper to dismiss. In one particular case, we're aware of individuals where they would have been delighted to have been made voluntarily redundant, probably foregone some of the pension payment, but of course it's extremely difficult for an employee to waive what would have been effectively accrued pension rights. So this case, as I say, the Donkor case, strikes right at the heart of an employer's ability to step around age discrimination by not offering redundancy to the wrong people. Legal background. Well, the legal background, Section 13 of the Equality Act provides that an employer directly discriminates against an employee if the employer treats the employee less favourably than it would treat a comparator because of a protected characteristic, and the treatment is not a proportionate means of achieving a legitimate aim. In this case, the relevant protected characteristic is that of age. In order to bring such a claim, the employee needs to use a real or hypothetical comparator, whose circumstances are not materially different to theirs. Pausing there, it's important to remember as well that in direct age discrimination claims, an employer uniquely has the ability to justify objectively its actions, even if it is discriminating. In all other cases, of course, of direct discrimination, employers are not entitled to rely on the justification defence, and that defence is usually something that's only available for indirect discrimination cases. Background facts, well, they involve Mr. Donkor, who worked for the Royal Bank of Scotland as an employee. There was a restructuring exercise carried out in 2012 and, as part of that exercise, RBS decided it was going to interview some members of staff for new roles within the organisation, and it was going to give others the option to apply for voluntary redundancy. Mr. Donkor was one of 4 regional directors at RBS affected by the restructure. As he was over 50 years old, any option to take voluntary redundancy would have included an option to access his early retirement pension benefits under the rules of the pension plan. This would have cost RBS in total, it's reported, a sum of over £500,000, and as such would have required sign-off at a very high level within the bank. 2 of the regional directors, however, were under 50. They were both given the option to apply for voluntary redundancy, but Mr. Donkor and the other regional director who were over 50 were not given that opportunity. Instead, he was offered the opportunity to apply for an alternative role, to which he was subsequently appointed. However, down the line, he brought a claim at the Employment Tribunal, arguing that the decision not to allow him to apply for voluntary redundancy was an act of direct age discrimination, and he compared himself against the other 2 younger regional directors who had been allowed to apply for voluntary redundancy. At the Employment Tribunal, the judge held that the 2 regional directors under 50 were not appropriate comparators, because they themselves were not entitled to the early retirement benefits that Mr. Donkor and the other regional director aged over 50 were entitled to. The Tribunal held this was a material difference between their circumstances, and therefore they were not suitable comparators. The Tribunal went on to find that even if they were appropriate comparators, Mr. Donkor had not been treated less favourably than. This was because none of the directors, the older or the younger ones, were given the option to apply for the early retirement benefits, and so the Tribunal could not see how he had been treated less favourably. Finally, the Tribunal held that any less favourable treatment was not on the grounds of age, but was on the grounds of the cost of his redundancy package, and the unlikelihood of this being approved by a senior manager. And, I suspect, somewhat unsurprisingly, Mr. Donkor appealed to the AT, and this is the AT decision. Well, they allowed the appeal and found that a prima facie case of direct age discrimination had been made out on the facts. The AT held that the Tribunal was wrong to find that the 2 regional directors under 50 were not appropriate comparators. The difference between their circumstances and Mr. Donkor's came down to their age. Because there was no material difference in their circumstances, that meant that it was then appropriate to treat them as comparators, and, as I'll explain in a second, the fact that one set could get enhanced pension benefits did not stop them being valid comparators. The AT also found there had been less favourable treatment because the comparators had been given the opportunity to apply for voluntary redundancy, whereas Mr. Donkor had not. This was enough to amount to detrimental and less favourable treatment. It did not matter that the comparators were not allowed to take early retirement benefits, because that was simply a consequence of their age. Finally, the AT rejected the Tribunal's finding that the reason for the treatment was not age, but was about other factors such as cost, legal risks, and the need to obtain approval from a higher level of authority. The AT held that all of those factors closely related and clearly related to Mr. Donkor's age. Therefore, it was the age that was the main reason for the detrimental treatment. Following clear line of case law on the topic, EAT held there was no need to inquire as to why RBS treated Mr. Donkor as it did, merely whether RBS had treated him differently on the grounds of age, which it found to be the case here. The AT sent the case back to the same employment tribunal to consider whether RBS could objectively justify such treatment. And it is very important, of course, to emphasise that argument remains open to RBS, that they are able to justify their treatment, potentially based on the cost of the enhanced pension benefits that will become available, allied to other factors. The case doesn't really establish any brand new legal principles. It's a useful reminder on the components of a direct age discrimination and how these can get confused. Having established that RBS had based the decision not to offer Mr. Donkor voluntary redundancy because of the early retirement benefits that would have been available to him, the prima facie case was made out. This is a situation where the decision to treat Mr. Donkor in a certain way was a direct result of his age. It was a direct result. Also, when considering who the relevant comparator should be in a direct discrimination case, it's important to remember comparator circumstances should not be materially different to the person bringing the claim. That being said, here the tribunal erred in its approach to the case because it found that the fact that the younger directors could not access their early retirement benefits was a material difference between them and the claimant. I think the EAT was, with all due respect, as they say, absolutely correct in finding this difference should have been disregarded because it directly came down to a distinction based on age. Clearly, it is very easy to have sympathy with the employer here. The pension benefits were materially different for the claimant. It was a significant additional cost. Why should an employer, faced with a potentially finite pool of resources to allocate to a redundancy, be forced to make someone redundant when that is going to be significantly more expensive? Well, I think the answer to that is that the entire pension cost here is directly linked to the employee's age. It would have been very difficult to change the facts just slightly, to argue that the younger employee was not a comparator when one employee was simply paid a higher salary because of his age than the other employee. In those circumstances, there would clearly be an age link, and so it wouldn't be a justification to make the younger employee redundant because the other one was paid more. That would clearly be age discrimination. I don't think there's any difference in the circumstances with pension benefits. So I think it follows from that the EAT was absolutely right here to say there was a clear age link to the younger employee, and so the younger employee was a valid comparator. As I say, the big question remains whether RBS can justify their decision not to offer voluntary redundancy. We're now in justification territory. As we know from case law, RBS won't be able to rely on cost alone as the justification for the discrimination, and therefore it will need to establish another legitimate reason, possibly alongside cost, for the treatment in order to satisfy the cost-plus principle. It remains to be seen whether RBS will successfully convince a tribunal of this or not. And, of course, RBS needs a legitimate aim and that its actions were proportionate. So it'll be interesting to see how they go about that. You think that some cases, and I have no knowledge about the inside on the RBS case, but you think in some cases, if there's a finite pool of money to spend on redundancies, and spending it in a particular way will generate greater savings than spending it on making a few very expensive employees with expensive pension benefits redundant. You certainly think cases in that sphere will have a fighting chance of being shown to be it's a legitimate and proportionate aim to want to achieve significant savings by the spending of significant money. Anyway, we'll see where that one goes. I suspect that will make its way back into the press if it fights, because, to take a step back from where I started, there are many employers that are in a similar situation and may wish to avoid offering voluntary redundancy, or indeed making compulsory redundancies, but offering voluntary redundancy to certain staff with lucrative pension benefits. So, third and final case is Siranyan. I apologise if I'm getting Mrs. Siranyan's name wrong. Sirunyan. Well, this is an unreported Court of Appeal case concerning a race discrimination claim, and the court had to consider whether an employer who had dismissed an employee for failing to demonstrate her ability to work in the UK, whether that was the result of race discrimination on the grounds of nationality. It's a sad story in some ways, as reported in the facts. Mrs. Siranyan was an American national married to a French man. Her husband was working in the UK by virtue of the EU treaty, of course, and as such, Mrs. Siranyan was also entitled to work in the UK as his spouse. In order to exercise this right under the EU treaty, it's typical for an individual to apply for a residence card, which provides official confirmation of that individual's entitlement to work within the UK. Mrs. Saranian applied for this residence card, but her application was refused by the UK Border Agency, it seems, on a mistaken basis. So she requested that the Border Agency review its decision to reject her application for residence, but prior to the outcome of this, she applied to work at NCO Europe Limited. She was successful in obtaining a role with them, and she was offered a position provided she could demonstrate that she was eligible to work in the UK. Under the Immigration, Asylum and Nationality Act 2006, an employer must be able to demonstrate that its employees are eligible to work in the UK, otherwise they'll be liable to pay a penalty. The only exception to this is where the employer can demonstrate that it has complied with the requirements under the Immigration Restrictions on Employment Order 2007. In Mrs. Saranian's case, NCO Europe asked that she provide evidence of her ability to work in the UK in accordance with their requirements under the Immigration, etc. Act. Well, she was unable to provide the evidence because she hadn't yet had the relevant residence card, and she did not hold a certificate of application for the residence card that was less than 6 months old. NCO Europe Limited concluded that in spite of the fact that she was married to a French national, she'd failed to demonstrate her eligibility to work in the UK. As such, if NCO Europe Limited were to employ her, they claimed they had been breach of the Immigration Restrictions on Employment Order and potentially liable to pay a fine under the Act. NCO Europe Limited even contacted the UK Border Agency to ensure they were correct in this assumption, and the Border Agency confirmed yes, indeed, NCO Europe would be open to a penalty if they employed her, as she did not currently have the requisite documentation to prove her ability to work in the UK. Consequently, NCO Europe Limited terminated Mrs. Saranian's employment, and she subsequently brought a claim in the Employment Tribunal. Her claim was for race discrimination on the grounds of nationality, and she claimed that a British national would not have been required to prove their eligibility to work in the UK, as she had been asked to do. Well, her claim failed both before the Employment Tribunal and on appeal to the AT. Before the Court of Appeal, she raised 2 points. 1, had she been treated less favourably than the relevant comparator? And 2, whether her nationality was the reason for that less favourable treatment. Well, in respect to the first point, she argued that the Tribunal and the EAT had both failed to establish the correct comparator, and the appropriate comparator in this case would be a British national who was permitted to work in the UK, but who was unable to provide the requisite documentary evidence of their eligibility. However, the counter-argument to this, which the Court of Appeal followed, was that the comparator here was immaterial, as NCO Europe Limited operated a blanket policy requiring all employees to provide documentary evidence of their eligibility to work in the UK. For Mrs. Saranian to succeed in her appeal, the Court of Appeal concluded she would have to demonstrate that although NCO Europe Limited had such a policy, it did in fact operate it. However, the evidence demonstrated that in fact it did operate a blanket policy, did require all employees, regardless of nationality, to provide evidence of their eligibility, and that this was specifically intended to avoid any claims of discrimination. In addition to this, of course, NCO Europe Limited had acted on the information provided by the UK Border Agency, and in accordance with the 2006 Act and the 2007 Order. As such, the Court of Appeal concluded no basis on the evidence for a finding of discrimination on the grounds of nationality, and her appeal was dismissed. Well, this is a useful reminder of the law in the area and the requirement to ensure, under the 2007 order, that all employees are entitled to work in the UK. Otherwise, in the event of a breach of the order, employers face potential penalties payable under the Act. Equally, I think this case provides useful guidance on how to implement policies in this area to ensure that any risk of a discrimination in claim is limited, by ensuring that such policies are applied to all employees and job applicants uniformly and regardless of nationality. The risk of a potential claim is reduced significantly. In addition, what appears to be significant in this case was the employer's ability to demonstrate how this policy applied to its own workforce and to job applicants in practice. The evidence that the employer was able to produce at this point significantly helped it in defending the appeal, and I think the case undoubtedly shows how helpful it is for employers to maintain clear and up-to-date records of how policies are affected, who they are being applied to in reality, and, best of all, apply them with a dose of common sense. They didn't just apply the policy, they also ran the UK Border Agency to check their understanding of matters. So, that's the Saranian and NCO Europe case. Do bear in mind, links to all the cases that we go through in the podcast are posted on my Twitter account, Nicholas Robertson, at Nicholas, Rober, then number one, Nicholas Robert 11. It's also on YouTube on the Mayor Brown employment section on YouTube, where we put out an audio version of this with the case names scrolling across the screen as we talk about them. Anyway, thank you very much indeed for listening to the podcast. We'll be back in 2 weeks' time, so take care until then. Thanks very much.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.